Hey, folks. My name is Robert Foho, and I am an attorney, a practicing attorney. I'm also somewhat of a recovering lawyer turned legal and political commentator. I wanted to take this episode as an opportunity to respond to what I think is a significant need in the marketplace. Many of my clients and friends, contacts, and referrals have reached out to me about how to put together a complaint or how to prepare and file a lawsuit. What I have come to discover and observe throughout my years of practicing as a lawyer and just over the last 2 years, as I have come into contact with a lot of people who have had significant disputes and beefs with the government, particularly in the government's response to COVID-19 and the various restrictions, lockdowns, and measures that were put into place. I've come to truly understand that there is a significant need in the market for legal services. The problem, however, is that most people unfortunately cannot afford attorneys. Attorneys are very expensive, there's no question. They charge hundreds of dollars an hour, and most people unfortunately cannot pay for that. They can't afford those types of expenses. A lot of people live paycheck to paycheck. A lot of people have very few in savings. So dishing out thousands of dollars for an attorney to prepare a lawsuit can be very cost prohibitive for people. Um, the other one of a few of the other considerations, a few of the other issues that I've encountered is that just getting a lawsuit off the ground at times can be very expensive. Putting together a very detailed complaint, undertaking the factual investigation that's required to put together the complaint, doing the legal research to determine what claims may apply, what kind of legal support, case law support you need to support the assertion of those claims, and just then the very administrative and ministerial tasks involved in getting the complaint drafted and prepared and finalized for filing. That effort is a multi-thousand-dollar effort. It would often take me a few $1,000s worth of lawyerly work to get a complaint prepared and do everything that I just described just to get a complaint finalized and ready to file. So that process, that type of effort is a considerable cost for people, and people just can't afford that. So that presents a significant problem when you have a lot of people who have significant issues that they need to address. Just over the last 2 years, in response to a lot of these COVID restrictions, people found themselves in some significant legal predicaments. For instance, take the case of the gym owners in New Jersey who refused to close their gym in response to, I think it was a local or a state order uh, to businesses that they needed to shut down in response to COVID. This gym refused to shut down. They got penalized and fined to the tune of hundreds of thousands of dollars. Well, a business in that situation has to defend itself legally. They need to retain an attorney. There probably was some kind of enforcement action in that situation that they had to respond to from their licensing authority. Perhaps there was a lawsuit of some kind by members or customers. And business owners in that situation need to defend themselves. Hiring an attorney is very expensive. Or perhaps you had individuals. I know of stories where individuals were arrested for refusing to put masks on. I know stories of people right here in New Hampshire um, who were arrested, for example, at a governor's council meeting, executive council meeting, and the arrests were unlawful, but those people are in situations that require legal representation, and just getting an attorney to help you defend a run of the mill misdemeanor charge can cost two, three, four, $5,000 at times, just right off the bat. So people have these legal problems, but they don't have the money to address them. They don't have the money to hire a lawyer to help them alleviate or help them address the violation of their rights. And that is the situation that I have seen come up so often over the last couple of years. Parents wanting to challenge a school district for its mask or vaccine mandate. Parents wanting to challenge a school district for its denial of a request for religious exemption. An individual wanting to challenge a municipal ordinance or a municipal order because they believe that it violates some constitutional statutory right that they have. In that situation, you need a lawyer and you need to prepare a complaint to initiate a lawsuit so that you can redress your grievances. But people don't have the funds to do that. So I think that there's a significant need in the market for a self-help option that people can access so that they can at least get the ball rolling themselves. There's no reason an individual cannot prepare a complaint to initiate a lawsuit themselves. It's not rocket science. It's just there's just a significant learning curve when preparing a document like this because it is so foreign to most people. A lot of people have difficulty writing as it is. When you throw in the structure of a complaint, the research that goes into it, the different components that it must contain, how things have to be phrased, it's certainly a difficult endeavor for many people to undertake. So I wanted to try and simplify this process and at least provide people with the information that they need to prepare and file a lawsuit themselves. So this is going to be a very basic sort of just broad brushstrokes style of workshop, if you will. I'm going to explain how to prepare and file a lawsuit. I'm going to describe the different components that go into the preparation of the complaint, and I'm going to walk you through the specific details and information that you need to include in order to prepare this document. Once you complete this and you have this information available to you, it should be fairly straightforward for you to be able to at least put together a bare bones complaint on your own and get it filed so that you can get the ball rolling on a lawsuit. That's my goal here, and I think that I can provide sufficient information for you to do that. So I put together some slides, and I'm going to run through this. So if you're watching this, you're going to see a lot. You're going to see some examples of what a complaint will look like. You're going to see my own work, and then I'll point out different things that I've done and how I do them. But if you're listening to this as well, you'll be able to take the information that you need in order to do this as well, even if you're not watching it. So preparing and filing a lawsuit. When I say lawsuit, what I mean is the complaint. Okay. That is the document that initiates a lawsuit. When you file a lawsuit, what you're doing is filing a complaint. And that is the first document in any lawsuit, in any civil lawsuit, is usually this document, which is referred to as as a complaint in most states. Years ago, New Hampshire used to call it a writ of summons, but they have since then dispensed with that terminology. That was very arcane terminology. Now it's just a complaint. And under the rules of procedure, one of the early rules, for example, in Massachusetts Rule of Civil Procedure number 3 specifies that a civil action is commenced by submitting a complaint and an entry fee or a filing fee to the clerk of the court. So this rule is the same as the rules in many other states. Every state has its own state rules of civil procedure, and then there's also a federal set of rules of procedure. The rules are largely the same from state to state. There's obviously some nuances and some deviations in every state, but the basic concept here is that a complaint is the document that initiates a lawsuit. Now, there are different stages of a lawsuit, and I'm focusing only on the first stage, the first phase, if you will, of a lawsuit. There is the beginning of the lawsuit, which is called the pleading stage. Okay. You file a complaint. Sometimes there's an answer. Sometimes there's a motion to dismiss. That's somewhat beyond the scope of this particular presentation, but for purposes of helping orient you, there's a complaint, an answer, or motion to dismiss. If you get beyond that, then you move into what's called discovery. After you get through discovery, you get to what's called summary judgment. Again, these are concepts that are beyond the scope of this particular talk. After summary judgment, then there's a trial. Okay. So I'm focusing on the first part of this process. It's known as the pleading stage. And specifically, I'm focusing on the initiation of the lawsuit, which is the filing of a complaint. So what is in a complaint? Well, it consists of several basic pieces. Okay. And what I've done here is I've laid them out in a sequential list, if you will, and I've referenced for each piece the rule of civil procedure that requires it or that informs or defines what it is. I'm using the Massachusetts Rules of Civil Procedure because I practice a lot in Massachusetts, but again, the rules are the same, mostly the same from state to state. There are, again, some nuances here and there, but the basic structure of a complaint is usually going to be the same or more or less the same or very similar in whatever state that you're in. And I have prepared complaints for Massachusetts cases, New Hampshire cases, Florida cases, federal cases, cases in Vermont, cases in Maine, cases in other states. And 99% of these documents are the same. So what I'm presenting to you here is going to be what you need to prepare a complaint in most of the states that you are in. So the first requirement that the complaint has to contain is what's called the caption, which is, and we're going to go through each one of these pieces in some more detail, but the caption contains the name of the court, the county, and the title of the action, and then a docket number, but you won't have a docket number at the beginning of the case, but again, I'll cover that in a second. And then a designation, which is essentially a title, the title of whatever document it is you're preparing. In this instance, it's a complaint. And that title needs to include the names of the parties, okay? And that's required by Massachusetts Rule of Civil Procedure 10A. The complaint itself and most documents filed in a proceeding have to have numbered paragraphs. That's, again, a very arcane and a traditional requirement for legal pleadings. A lot of lawyers have sort of moved away from that, but at least for a complaint, they need to be numbered paragraphs, because what happens is when the defendant files an answer, the answer contains a specific response to each paragraph in the complaint. And that's the most efficient way to match each response to each allegation in the complaint. The third requirement is the complaint obviously needs to identify the parties, the plaintiff or plaintiffs, and the defendant or defendants if you have multiple parties. And the complaint has to identify an address or a place of business for each party, because that information is necessary. It's required by the rules of procedure. And if you have defendants, you need to be able to serve these individuals or businesses. So you need to provide their contact information, if you will. The complaint also needs to identify the jurisdiction and venue. And by jurisdiction, I'm referencing the court's subject matter jurisdiction, but also personal jurisdiction. And I will address these concepts in a few minutes. By far, the most important portion of the complaint that you need to include is a factual description of what happened, okay, and the claims that you have. And these are separated into counts. And those usually appear towards the end of the document after you've laid out the narrative or the story of what transpired that gave rise to this dispute. If you have any exhibits, for example, if you are filing a complaint that contains a breach of contract claim, you should attach a copy of the contract as an exhibit to the complaint. And if there are any other documents that are important or that relate to any of the facts that you allege in your complaint, you should include them as exhibits in the complaint. I always err on the side of more detail in the complaint because that will help you survive a motion to dismiss. And that'll also do a good job of informing the defendant or defendants of what happened, and at least putting your best foot forward if you have any hope of resolving this dispute. The final piece of the complaint is called a prayer for relief. I call it a request for relief, but it's usually called a demand or a prayer for relief. And that is nothing more than a request for what you want. Okay. It could be damages, it can be an injunction, or it could be some other form of relief. I'll get into that in a few minutes. So let's look at the first requirement, the caption. So this is a complaint that I prepared recently, and it's for a lawsuit in Massachusetts. So at the top here, what you're going to see is in whatever state you're in, you're going to list the state. So this is in Massachusetts, so naturally it will identify as the Commonwealth of Massachusetts. Then on the left side, you're going to see the identification of the county in which this lawsuit was filed. On the right, you're going to see the name of the court, which is the Superior Court. So we are in Massachusetts Superior Court in Bristol County. There is no docket number right now because, again, this is the first document that initiates the lawsuit. After this is filed, the clerk's office assigns a docket number to the case, and then every document or filing after the complaint will contain that docket number. So you will affix that docket number, you will insert it to every other filing, every other document that you prepare for this case. You will insert it into each of those documents after the clerk's office assigns it once the case is filed. And then on the left-hand side, that box that you see, that is what's considered the title of the case. When you refer to a case, you always refer to it as A versus B, plaintiff versus defendant. And in this instance, the plaintiff is listed at the top. The defendants, there's two defendants here, they're listed underneath the plaintiff. And that is the name, that is the title of the case. And it necessarily has to include the parties in accordance with the rule of procedure that I identified 2 slides ago. So this is what's known as the caption. The upper half of this page, that is the caption of the complaint, and that caption will be included in every document you file after the complaint, whether it's a motion to dismiss, whether it's a motion for summary judgment, if it's a set of discovery requests like interrogatories or requests for production. Every document is going to include this caption. It is unique to the case, and it is consistent throughout the case. Numbered paragraphs. This is fairly straightforward. The complaint and every filing in the case has to contain numbered paragraphs. And this is very easy to do if you have a word processor like Microsoft Word or what have you. You just number each paragraph. You hit the tab that moves the cursor over about 1/2 inch, type a number, hit period, hit tab again, and it automatically starts formatting it for you. Then if you hit enter and you move to the next line, it'll automatically insert a number 2 for the second paragraph. Very easy to do and to do consistently in a document like this. But every allegation, most lawyers will try and confine each sentence to a paragraph, but most lawyers will group them up. You'll see in this document, I have several sentences per paragraph, and it's fine, however you want to do it. But what you want to do is confine each idea that you're trying to convey into one paragraph, whether it's 1 sentence, 2, or 3. And that's what most lawyers try to achieve when they're preparing a complaint. And that's what you'll see in this document. But every allegation, every argument that you're trying to convey, every fact should be organized in a series of paragraphs as you see in front of you. Parties. The parties will appear at the beginning of the document. So after the caption, there's usually some kind of an introduction. I always include an introduction of some kind. And then you will have a section identified for the parties. And what you'll do here is take a paragraph and identify each of the parties. So here I have the plaintiff identified and a place of business for that organization. And then in the next paragraph, I have one of the defendants identified and an address as for the principal place of business for that defendant. And you need to do that for each party. If you have 2 parties, then you have 2 paragraphs like this. If you have 10 parties, then you have 10 paragraphs like this. So it can be somewhat of a nuisance and cumbersome if you have multiple parties, but it is a requirement and you need to include this information in the complaint. The next section is the jurisdiction and venue. And that's another section that is clearly identified in the complaint, and it's not required necessarily under the rules of procedure, but the statutes that govern civil actions in every state will usually require that you establish a basis for two types of jurisdiction and for venue. So let me walk you through each one of these. Subject matter jurisdiction is the court's jurisdiction over the dispute itself. So the court, for you to be in Bristol County Superior Court in Massachusetts, that court needs to have jurisdiction over the dispute that we're addressing. Usually the Superior Court has jurisdiction over all types of civil disputes. But if you have a dispute like a family court matter, a divorce or a child custody dispute, that belongs in the family and probate court. That is the court that has subject matter jurisdiction, or that has jurisdiction over that dispute, that subject matter. If you have a small claims case, okay, that dispute belongs in a different court. If you have a landlord-tenant dispute, that belongs in an entirely different court. In New Hampshire, there's landlord-tenant court. In Massachusetts, you have land court. If you have a federal claim, a federal dispute, or a dispute involving a federal question of law, that belongs in federal court, not in state court, not in Massachusetts Superior Court. So you need to understand what kind of dispute you have and which court can address or have jurisdiction over the subject matter of that dispute. And you need to specify specifically which statute gives the court that you're in the dispute over the subject matter, or the jurisdiction over the subject matter of that dispute. All right. The second type of jurisdiction is called personal jurisdiction. And that is nothing other than the court has to have jurisdiction over the parties, or at the very least, the defendant. A court cannot adjudicate a dispute involving a party that has no contact with the state in which that court is located. So if you have a contract dispute with somebody who has never been to your state, someone who entered into that contract with you elsewhere but not in that state, you cannot sue that person in the state that you're in. You need to go and find them and sue them wherever they are. That's an oversimplification of it, and there are some nuances and there's some variation to that concept, but that's normally how it works. If you got into a fight with somebody and that happened in another state, you can't sue that person in your state. You need to go and find them and sue them there. Now, the internet has changed the way things work. For example, if you purchase a product online from a website, and say you're in Massachusetts and you bought in this website, or this business is located in Florida, the fact that that website is available to be reached in Massachusetts, the fact that that website, that you bought that product through the website and that product was then shipped to you from Florida, that potentially can establish personal jurisdiction over that business in Massachusetts because of the way the internet works. And courts over the last 20 to 30 years have understood and recognized that things are changing in the world of e-commerce. But generally speaking, you need to make sure that the court has jurisdiction over the parties to the dispute in order for you to be able to file the case in that court or in that state. And then finally, there's the concept of venue. Different states have different counties, and courts sit in different counties. So if we are in Bristol County, at least one of the parties or the event in question had to at least one of the parties has to either be domiciled in that county, or one of the events has to have occurred in that county. If that county has no connection to either the parties or the event, or the events in question, or the dispute that occurred, then venue is not proper. You need to go file it in the county where this dispute occurred, or where the parties are domiciled. All right. So venue also has to be established. There's usually a statute that establishes and explains what is required for venue. Every state has one, and it will be very informative as far as letting you know what you need to have, or what requirements you need for venue when filing in a specific county or district. So that's jurisdiction and venue. Now, on to the facts and the counts. So let's start with the facts. The facts in your complaint, the factual background of the dispute, is nothing other than telling a story. You need to just explain what happened, but you also need to be careful not to assume that the court or the judge or a jury is going to know anything about your dispute. So you have to start from the very beginning and explain everything that happened. It's helpful to be descriptive. I like to be as descriptive as possible. And if there's some background information that you need to explain, so for example, if you are a business and you are in the if you are a liquor warehousing business, okay, I had a case like this once, and you start to explain how you had a liquor warehousing contract with the state, and that contract required you to do X, Y, and Z. You should not assume that a judge reading that complaint is going to know anything about the liquor warehousing business. So you should take the time to explain the industry in some detail. Don't go crazy, but make sure you provide enough context for whomever's reading this document to know what the hell you're talking about. So be descriptive and provide background where necessary. Help me understand your story and why it's important and why I should care. That's the perspective from which you need to approach preparing one of these documents. And in fact, before I get to the claims, let me just show you one of the complaints that I've done. So this is the same complaint I was just showing you. And if once you get past the jurisdiction and venue section, there is a section called factual allegations. And this is where I lay out the legal background for this dispute. I lay out, for example, this is a case involving vaccine mandates in 2 school districts. I lay out what laws govern schools and school districts and school committees. I lay out what their responsibilities are, what their authority is, and then I lay out what authority lies in the state to administer vaccine requirements. And I go through this in a lot of detail. I want to inform whomever's reading this how this legal structure works so that they can then understand why we contend that there is a problem with a vaccine mandate in a school district or school district enacting a vaccine mandate. So I take the time to go through all of this information. And then eventually I get to the specific facts at issue here, which is the 2 school districts that issued vaccine mandates, when they did them, what those mandates say. I quote directly from them. So I provide a lot of detail and I provide a lot of information for the reader of this document so that the reader knows everything just from reading the document. They know what happened. They know what the legal background is. They know what the legal requirements are. And they know essentially everything they need to know once we appear before that fact finder. That's the goal of a complaint. It's to tell a story, but tell a complete story so that whomever's reading it knows why you're telling them that story, knows why it's important, and knows why there's a problem. Let me get back to the slides. All right, so facts. Tell a story, be descriptive, and provide background where necessary. The next section is the counts. These are your legal claims, okay? And they have to be set forth separately. So each claim is a separate count. And I'll show you what I mean by that. So this is, again, the same document. After you read through the facts, you get to the section titled claims. And in this section, you will identify each claim you have against either both defendants or one of the or each of the defendants, and you label them as counts. So count 1, you identify the claim that you have, and you lay out the elements of that claim. Another phrase for claim is cause of action. Every claim has a specific number of elements that you need to satisfy in order to prove it and prevail. Think of it as a geometric proof. Okay. So there are 4 requirements. You lay out what those requirements are and why they apply here. So you need to link each of those requirements to the facts of your case in this section of the complaint. So let me give you an example. Say you have a breach of contract claim. All right. There are 4 elements to a breach of contract claim. Number one, you have a contract. Number two, there was a breach of that contract. Number three, you have damages as a result of the breach. And number four, the breach caused the damages. Okay, so you have 4 requirements for a breach of contract claim. So your count for that claim in your complaint should say, so the parties you have are A and B, let's assume for the sake of this example. Plaintiff is A and the defendant is B. So A and B had a contract. You've laid out the first element of a breach of contract. B, the defendant, breached the contract by, and you explain why or how B breached the contract. So in this instance, B failed to provide services that he agreed to provide to A. All right. And then as a result, so that's the causation piece of this. As a result, A suffered damages from the breach. Let me give you another example, a negligence claim. Now, negligence has 4 elements as well, the same as a breach of contract. They're not the same elements, but the same in number. So a negligence claim consists of a duty of care, a breach of that duty, causation again, and then damages that flow from the breach. Okay. So in this instance, you'll allege that B had a duty of care to A. So think of a car accident. B, in driving his or her car, had a duty of care to A, had a duty not to drive dangerously or to run a stop sign or run a red light. B then breached that duty by running a stop sign, running a red light, driving over the speed limit, so on and so forth. But for B's breach, okay, so this is the causation piece, B would not have struck A, or B would not have crashed into A, or B would not have hit the curb, or B would not have swerved and hit A. And then the fourth allegation, as a direct and proximate result of that breach, A suffered damages to his or her car, personal injuries, so on and so forth, lost wages for missing work, medical bills, expenses. You can obviously be more descriptive than this, but at a bare minimum, this is what you have to include in the claims section of the complaint. You need to lay out the elements of each of your claims and separate them into counts. The last piece of the complaint is called the prayer for relief, or a request for relief, or demand for relief, as it's called in the Mass Rules of Civil Procedure. And all this is just a request or a demand for what you want. And there are generally 2 types of relief that you can request. And those fall into 2 buckets: monetary damages, like compensatory damages, money, a money award. So if you got into a car accident, you suffer injuries, you suffer damage to your car, you need compensation to reimburse you for those losses. That takes the form of compensatory damages. Alternatively, you can request an injunction. So if you are challenging a school's issuance of a mask mandate or a vaccine mandate, you are requesting a court order that prohibits the school district from enforcing that mandate. That is known as an injunction. It's a court order that tells somebody not to do or not to do something. You can also ask for other things. For example, you can request that the court reimburse you for the attorney's fees that you have. So if you had to pay an attorney to help you with this case, if there is a statute or a contract allowing it, you can ask the court for an award of your attorney's fees to get reimbursed for your attorney's fees. So those are the usual types of relief that you can request. You can also request punitive damages in some situations. Those are damages that are intended to punish a defendant for some kind of wrongful conduct. But that's usually what it is. So it's either money damages or an injunction. And that's essentially it. That is a complaint in a nutshell that provides you with the information that you need to prepare a bare bones complaint. The most significant portion of it is the factual background. It's the story, the facts you want to tell, how, the who, what, when, where, why, and how, and why that story is important, and why it's an issue, and why you are in court disputing this problem. If you have any questions, feel free to hit me up on any of these platforms: Twitter, Facebook, Instagram. Our handle is Law of Foho. And if you want a sample complaint, I can always send it to you. Just email me at rfojo at lawoffoho.com. Again, that's rfojo at lawoffoho.com. I'll shoot you a sample complaint that you can see, complaints that I prepared and filed in court. So you can see some examples of what these documents need to look like. But again, I provided you with the basic information in this podcast, and this should be sufficient and helpful for you to be able to put one of these documents together yourself and initiate a lawsuit on your own. So thank you for listening to the Law of Foho podcast. Feel free to leave us a review on Apple Podcasts, and always follow us on Twitter, Facebook, Instagram, and Truth Social. And yeah, we're on Truth Social. We're also on Locals as well. And we look forward to seeing you next time. Thank you for joining us, and see you next time.